We're here on the state of Florida versus Ashley McArthur, case 17 CF 5844. Defendant is present with counsel, assistant state attorney is present. The first thing I thought we might do is review, and I need somebody on behalf of Court TV and to come on up, just to talk about the placement of microphones and what's happening. We've also got WEAR here briefly coming and going, but come on up and tell me your name.
Ted Rollins.
Oh, how are you?
Good.
All right, so can you just, so everybody knows, first of all, is there a microphone at Ms. Jensen's bench?
No.
Is there a microphone at the defense bench?
No.
And right now, the court is muting both microphones from the court-smart perspective. So you should not have to hold down the microphone, but if you speak loudly, people can hear it. That's just normal life. All right, then tell me about where we have microphones placed, Ted.
There is a microphone, a judge's microphone, there will be a witness microphone. There's one in the well here, and then one at the podium. Okay. They're all controlled from the back, so if there's a sidebar or if there's anything...
I'm waving at people in the back and they're not really acknowledging me, okay.
So that whenever there's a sidebar, we bring the microphones down. So,
down meaning it's mute.
Exactly.
Okay. Now, is there any, I think we talked about this, you and I, but just so we talk about it in front of the attorneys and Ms. McArthur. If you mute, you're going to mute all the microphones, so you should, and as long as I mute up here, you should not pick up anything, correct?
Correct. We won't hear anything. As soon as you call the sidebar, we bring them down.
And when we take breaks, what's your intention? Because sometimes people are talking around microphones. Is it your intention during breaks to mute it as well?
Yes, during breaks, as soon as we're off the record, we would put our cameras to the seal of the great state of Florida, and all the microphones are down.
Okay. And I was trying to think what else I had on the subject. Y'all may be also have your own phones that might be doing some sort of recording or doing something. Is that correct? No? No,
we won't be recording. The local affiliates and Law&Crime that are streaming and recording different aspects of the trial, about the entire trial.
And y'all, obviously, from the position of the camera, are not going to in any way film any jurors, correct?
Absolutely.
Now, there's one other camera. There's that camera that y'all's the one that's the tallest, and then the one next to it, I think, is WEAR. Hey, that camera, where is that going to be positioned?
That stays right there, and it is operated remotely from the back. Both.
Exactly.
Yes.
Okay. All right. So, is it your intention from the back, though, for that ever to be on anything other than defendant or defense table or whatever?
This will also pick up openings, closings, they'll both move around and pick up, potentially pick up the witness later.
Okay. But will not in any way go towards the jury?
No.
And so if I saw that, I could jump across, lunge there, and stop the camera.
Absolutely.
And that would be worth getting on film.
Yes, we would.
Okay. All right, so I don't have to spend my time watching cameras because I want to watch the trial, pay attention to the trial. They are absolutely not going to float towards the jury.
Absolutely.
Okay. Ms. Jensen, do you have any, and I think WEAR is here and they put a microphone right there on the ledge, and...
Mine is actually on the podium, and I have one microphone on the camera that just picks up natural camera
Okay.
sound.
I guess that one on the ledge then is maybe it's our button. Oh, okay. Something else is going to occur to me in a moment. Oh, the final thing I wanted to say, which I've said already, and I know everybody that's in the media understands this, but no matter what access we're giving folks is the ability to watch this. To me and to Ms. Jensen, to the Barossets and Ms. McArthur, it is about this trial and a fair trial and justice. So it's critically important that your folks, I mean, right now I see them way in the back. They're very discreet. WEAR is typically discreet, but we really want the jury to forget about this being streamed. And, okay, and I've got some assistants to keep me on track too. I think that Casey Watson, our PIO, clarified that y'all's folks might be texting or doing something with their phones back there, and I'm authorizing that because that may be part of their job. And the final cautionary note before I ask the parties if they have questions is, even though they are muting the microphones, if you're going to have a substantive conversation, it's probably smart not to do it right here in the courtroom with all the microphones around. So that's a caution. Even though I'm sure everybody is very well-intentioned and professional, that's just a caution. Ms. Jensen, can you think of anything? I have to talk to the people here watching. That's a separate conversation, but any questions you have?
No, Judge, my only concern is that hot mess of wires down there by the cart. But I guess it is what it is. They moved the projector or my cart, and that's not going to be where it's used tomorrow. So I don't know if that. I don't know why you moved
that
it.
in the morning or
Okay.
after
Okay.
today.
I might can try to find something for you in court administration. We might have a mat we could put down if it's not going to damage the cords for tomorrow. I can ask. I've got one in my chambers if nothing else, and then maybe you're not stepping all over cords. If that, remind me of that, and I can check into it. Anything else you can think of? Mr. Barry Barosset?
No, Your Honor.
Mr. John Barosset?
No, Your Honor.
Okay, I think we're good. I'm going to talk to now let's talk about who's here watching the trial and what's happening. In spite of the fact that we have a live stream, you're not to pull up the live stream on your phones. You're not to be on your phones. You're not to record anything. The media gets to do certain things the public does not get to do. You are getting your official warning now. If court security sees you recording or texting or doing anything, you're done for the day. If you want to watch the trial, you're welcome to be here. Now, another thing, it's distracting when people come and go from the courtroom. Other than court staff or defense, not court staff, but Ms. Jensen's office, Mr. Barosset's office that may be assisting them. See, just that. Court security can't help coming and going. You all turn to look. That's what happens if y'all are getting up and down during the trial itself. There are plenty of opportunities to come and go when the witnesses change or when the attorneys change. If you need a break or you do need to make a call or do something outside, then that's your opportunity. I really discourage it because every time somebody goes out, everybody swings to watch. So whoever you are here in support of, you want the jury to pay full attention to the testimony and evidence. So it's not that you can't come and go, but please be courteous. But do not, the fact that you see the film folks or somebody on their phones is a different thing. That's their professional. You should not be on your phones in my courtroom. And if there's a problem, and I don't want you reacting to testimony, shaking your head, do anything. If you do it, you're gone for the day. We can try starting over fresh tomorrow. And then, Ms. Jensen, I think you only have one witness today, potentially, but tomorrow we're going to have probably a number of witnesses. People are not supposed to feed information from the courtroom about what's happening to witnesses or engage them outside in that way. So if somebody who's your friend or family member is a witness, leave them alone and do not overnight report about it. So even though we've got all these cameras and lots happening, don't be sharing information. Ms. Jensen, is there anything else you want me to share with the group? Mr. Barosset?
No, we want to invoke the rule as
Okay.
far as the witnesses.
I have
All
one
right.
witness and he's outside.
Okay.
The only witness that's for the whole trial that's in here is not in here, he's outside.
I just want to make sure no witnesses are in the courtroom.
Even defense witnesses.
Correct. I want to make sure none. Okay.
We have a lot of people here. Anything else, Mr. John Barosset?
No, Your Honor.
Okay, I think there was some motions y'all wanted to renew.
Judge, as you may recall for the record, John Barossi, I filed a motion to suppress Ashley McArthur's statement to law enforcement on October 19, 2017. The statement on October 19, 2017. My argument was that clearly Mrs. McArthur was in custody. Law enforcement took their time, delayed giving her her Miranda rights. Then when they did issue her Miranda rights, flew through them very quickly, and I think the statement was something like, I'll breeze through these really quickly, thus downplaying her rights. And based on that, we asked the court to suppress that entire statement. And again, we would ask the court to change its ruling and suppress that statement from October 19, 2017.
Anything you want to say, Ms. Jensen?
No, Your Honor.
All right, I'm going to continue to deny the motion to suppress. Is any other things of that nature that need to be renewed?
Yes, Your Honor, we had filed a motion in limine to preclude the admission of certain conversations between Ashley McArthur at the Twin Peaks restaurants, certain other witnesses as hearsay. We had also moved to exclude text messages between Taylor Wright and Ashley McArthur between August the 29th, 2017 and September the 6th, 2019, which the state had produced, and text messages between Taylor Wright and Cassandra Waller as hearsay.
Okay. I believe I entered an order denying those motions in limine, but outlining, I think, some points in those, and I will continue to rule consistent with that, but that is considered renewed for purposes of the trial. Anything else? Ms. McArthur, of course, you're free. You've got a notepad. You're free to communicate with your attorneys at any time. Just a reminder, you please do not react in front of the jury. I have the standard jury instructions to read. I don't know who's doing opening. All right, Mr. John Barasset, do you want me to read right to remain silent?
Yes, please.
Okay, will do. I think someone in here, just to clarify, someone in here has a medical pump that's connected to their phone that might make a beep noise. So if other people hear that, that's what that beep noise is about. That's okay. I didn't want people to think there's one set of rules and then another set. But I think that's tied to some medical stuff. So I'll read the standard instructions. I will ask them some questions. I will offer notepads and pencils, and then we're going to get underway. Everybody good to go?
Judge, the last thing I have is when we were in jury selection, I brought it to the court's attention. The gentleman in the second row in the blue shirt was kind of huffing and puffing when we were talking about law enforcement lying or not always telling the truth or something like that. So I'm just going to ask the court to make sure everyone, not just this gentleman, but everyone doesn't make any facial expressions or anything while the witnesses are testifying.
And again, it's a reminder, I've already said that, but if we see that, you are going to be done for the day. So please just listen. And when we get to a point where there might be autopsy or photos or anything like that, we are good about announcing that so everybody knows. But do not react in front of the jury. If there's nothing, I will go ahead and report that there was a lost juror I bumped into, which is why I was late, on the 4th floor, but I secured her and got her to the 2nd floor, and now, hopefully from now on, she's good to go. So I think that was Miss Butler, and obviously we did not discuss the case. I think with that, we're ready. All right, and everybody may have a seat. For the record, we're here on the State of Florida versus Ashley McArthur. Defendant is present with counsel. Assistant State Attorney is present. Well, good afternoon. You're now my people. Okay, thank you for being back. And I see a smile, so that's good. We're back, and what I'm going to do is I'm going to talk to you about a few things, and I'm going to read you some instructions and tell you a few more things, and then I'm going to turn it over to the attorneys. All right. The first thing is this. You're already under oath. You've already been sworn. Has anybody approached you about the case? No. Has anybody tried to talk to you about the case? Has any of you done research on the case? Has anybody called somebody at home and said, hey, let's live stream this thing, you see what I'm doing today? No. All right, let's talk about the media for a second. I'm going to talk to you before we leave today, but there's cameras here, there's camera over there, there's microphones. This has nothing to do with you. If anyone has to sit up straight, it's me. If anyone has to put on lipstick, it's me. They are not going to be filming you. I do not want anyone to worry that somebody is going to turn a camera on you while y'all are listening to this case. So set that aside, okay? And then we'll talk about tonight and going forward the rest of the week on the media aspect of it. But I do not want you to worry about that at all. Now, what I talked to you about this morning was the fact that this is serious business that we're doing here. But I also said that it's hard to sit here with the jaw clenched for 4 or 5 days. So I want you to take a deep breath. And there are going to be times when we're on a break or something else, and I may talk to you about a completely unrelated topic. Or probably I'll just spout off about a topic, okay? That doesn't mean it's not serious. It just means you might need a break. At any point, if y'all need to stand up or whatever, that's fine. I'm going to read you some instructions, okay? Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Ashley Britt McArthur. This is a criminal case. The defendant is charged with first-degree premeditated murder. The definition of that crime will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state has proved its accusation beyond a reasonable doubt against the defendant in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, attorneys will have an opportunity to make their closing arguments, and following the closing arguments, I will give you the law applicable to the case. And then you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and instructions on law by me. Until that time, you should not discuss the case among yourselves. That includes not asking court security any questions about the case or giving them an opportunity to comment on anything. So that includes them as well. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about the case. And that means, now you should have left your phones in the back or whatever y'all brought. And there's a reason we do that, just so there's no temptation during the day. But I know I'm sending you home at night to the land of electronics, so I know that there's some trust back and forth between us. But no communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case, look up information about the case, and if you become aware of a violation of these rules, you have to let me know by telling court security. During the course of the trial, I'm going to take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone or permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell that person you're on the jury trying the case and ask them to stop. If they persist, you tell court security. You're going to have these 3 officers all week. They're good officers. So you're going to form relationships with them too, and just talk to them. And you know that I'm not letting you have any cell phones, tablets, laptops, or other electronic devices in the courtroom, and I've asked you to put them in the lock boxes back there. You know that I do not want you to communicate or find out any information about the case or take photographs, video recordings, audio recordings of the proceedings or your fellow jurors. And at the end of the case, when you're deliberating, you must not communicate with anyone outside the jury room. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. And of course, then you can make a phone call or whatever. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, attorneys, and myself. And again, it's kind of repetitive, but I have to keep reading it. You must not conduct any investigation of your own, and that includes reading newspapers, watching television, or using a computer, cell phone, or the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you're here or at home or anywhere else. You must not visit the places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. And I'll talk to you again about this tonight, but jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. And again, that applies on electronic devices as well. So if somebody texts you, it's the same thing. You must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to the case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reason for these rules? I think you know the reason. They're imposed because jurors must decide the case without distraction and only on the evidence in this courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and taxpayers. If you violate the rules, you can be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. Now, the last thing I want to do is spend the morning encouraging you to be good citizens and then put somebody who's a juror in jail. I know you get what I'm saying. It's serious business. Okay. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it will be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conference may be required or how long it will take. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. All right, a couple of other things. First of all, we had somebody walk in, and it's human nature to turn and look. What I've asked folks, this is a public courtroom, public access. But I've asked people to be considerate and try not to move around except when we change witnesses or change attorneys. But do your best. If somebody's moving around over here, that doesn't matter. This is what matters. Everything in front of here. Sometimes jurors are interested in, what's my trial notes here? Hang on a second. Okay. Sometimes jurors want to take notes, and this is going to be a long trial. Like I said, I'm not sure exactly when it'll finish, but it'll finish by Friday. We have notepads and pencils for your use, and if you're interested, we'll hand those out in a second. But there's some cautions. If you take notes, it is human nature to be looking at your piece of paper when you write, and you may miss a reaction on the witness stand. So be careful to keep your head up, because you want to watch. That's how you assess credibility of witnesses, is watching, not just listening, but watching. Also, the other thing is that if you take notes, the fact that you write something down doesn't give it any greater weight than the memory of another jury. So if you write down red sock and everybody else remembers blue sock, just because you wrote it down doesn't make it somehow more powerful. What we do with the notepads is you have them there. You're going to write your name on the first page and flip to the second. You're not going to take them in the back with you until we deliberate. In the meantime, you leave them out. Nobody touches your notes, and at night, Renee or Parker who are my clerks, are going to secure your notes. But nobody ever reads your notes, even after the case is over. They destroy your notes. So those are confidential. But just be careful of the cautions I've given you if you decide to take notes. Does anybody want a notepad? If you don't want one, it's okay. We're going to get pads out, and then we'll get you pencils. We got the big, thick ones. And then just write your name on the first page, please, just that. But if you choose not to take notes, all of you the same, whether you take notes or don't take notes, it's important that you pay close attention. And because you're going to be going back in that jury room at the end of the week, and something that today is clear as a bell, in 3 or 4 days, you may be kind of trying to think back. So everybody pay attention. I think it's helpful if you know what to expect during the course of the week. We may or may not take a break today, because I think hopefully we'll get you on your way a little bit early. But typically what we'll do is you'll come in, we'll start, and you get a break about 10:30, a comfort break. And by the way, we should have snacks and drink water back there for y'all. And if anybody wants to get a Coke or anything like that, that's fine, and we can take you down to do that. But that makes it easy for y'all to have snacks, and we'll replenish those, okay? At lunchtime, every day you're going to fill out an order form for lunch, and we'll take care of lunch at the county's expense, and then I give you an afternoon break as well. But the main thing I want you to know is if you're sitting there and you're looking at the clock thinking, I know I can make it to the break, don't do that, because I want you to be paying attention. If you need a break, raise your hand. If anybody needs to stand at any point because they're uncomfortable, that's okay too. You're my people. I'm going to take care of you. You just have to let me know. Okay? If you can't hear something, let us know. When we put stuff up on the screen, if you can't see it, let us know. All right? Final couple things. You see me up here. I'm on the computer. I am not on eBay, and I'm not on the Delta website. Okay? So if you're wondering what I'm doing, I have the ability to look at the files on my computer, communicate with my office, sign orders. If you see me on the computer, I'm also taking notes on the trial. Renee and Parker are here. They're in charge of exhibits and keeping up with the witness list, and I sometimes confer with Renee. And we have our court reporter here. We usually have a different court reporter every day. Finally, if we do ask everybody to approach to the bench, all the microphones should be muted. If we're doing that we're trying to have a conversation outside your presence without having to send you out. Every time I move 15 people, it takes a long time. So if we can do it up here, we will. It's human nature to sort of lean forward and see if something juicy is being said. Don't do that. It's a good chance to stand and stretch. All right. I think I've covered everything. I think of Ms. Jensen. I'm going to turn it over to you.